So after the decedent passes away and he owns the house by himself and his spouse is not on the house, well, generally, you're not going to be in a situation where there's a deed that will be done. The answer is, in fact, probate. Here's the situation. So if it is the decedent's homestead, there's a variety of things that come into play because there are special rules that work around the homestead. What ends up happening is the Constitution says that if only her husband's name was on that deed at the time that he passed away, by law, she gets the life estate, meaning that she will own the house for the rest of her life. And if they had children, or shall I say, if the decedent had children, then her husband's children will get the house after she passes away. Now, of course, if he has no children, then she gets the 100% ownership of the house, but that's going to be part of the probate process. You can't do a deed unless it's not the homestead property. And say, for instance, it's some sort of rental property, then you would have to do a personal representative's deed, where the court will appoint a personal representative who would then have authority to actually sign the deed over to the spouse or to whoever is supposed to get it. And by the way, if it's not the homestead, if the decedent only has children with his wife, the wife gets 100%. However, if her husband has children with somebody else, she gets 50% and the children share the other 50%. But that's the only way that a deed actually comes into play. But generally, most people primarily only have their homestead property. And in that particular instance, she'd end up with a life estate where she owns it for the rest of her life. And then it's going to go to the children, of course, unless they have no children. But it's a probate issue. I'm attorney Marcus Sermons, and this has been another episode of Interesting Lawyer Stuff.